Welcome, and thanks for joining me. My name is Michael Moiso, and I'm a professor at Clackamas Community College. This presentation sets out the legal basis for an appeal to the U.S. Supreme Court of a lower court decision involving treaty rights over ownership of the Wallowa Valley in Oregon that was taken from Chief Joseph's band of Nez Perce in an 1863 treaty. Raise your hand if you've ever heard of Chief Joseph. Well, whether you've heard of him or not, getting the Wallowa Valley back for his people was a central part of his story and at the heart of this suggested appeal. This is just a quick review of the issue, so if you're interested in the full argument, go to chiefjosephappeal.org and read the main article. The idea here of an appeal is not original. The purpose of this presentation is to support the idea of an appeal and to build a coalition that will help Chief Joseph get the Wallowa Valley returned to his people. This is a story rich in irony. There have been a plethora of books and articles written about the plight of Chief Joseph and his band of Nez Perce. This slide shows the covers of two New York Times bestsellers written in 2005 and 2017 that provide amazing accounts of the failed negotiations of the 1863 treaty and Chief Joseph's attempt to flee Canada with his band. That is just two examples out of hundreds of books written about Chief Joseph. There was also a movie made in 1975 about the attempted flight to Canada and the many battles with the Army along the way. This slide shows a cover of the movie. Chief Joseph's war blanket was sold in 2012 for $877,000, proving his notoriety as a military strategist is still intact. The irony is that Chief Joseph didn't want this notoriety. Rather, he wanted the focus to be on his legal argument to get the valley returned to his people. He believed the Wallowa Valley was essential to their survival and to the preservation of their language and culture. He spent the remainder of his life sharing this message and lobbying for the return of the valley. But it turns out his story isn't over. But let's first take a moment and look at some of the history, and then we'll discuss the legal basis for the appeal. The Nez Perce first signed a treaty in 1855. They were given 7 million acres. It included all the territories owned by the individual bands, including the Wallowa Valley that belonged to Old Chief Joseph's band. In 1863, gold was discovered, and the government sought a new treaty, taking back 90% of what was granted in the 1855 treaty, leaving them only 700,000 acres that no longer included the Wallowa Valley. Old Chief Joseph rejected the 1863 treaty and did not sign it, nor did a substantial number of the other chiefs, all who had signed the 1855 treaty. The government ratified the 1863 treaty nonetheless with only a simple majority of signatures. Chief Joseph's band continued to occupy the valley after the 1863 treaty and continued their efforts to get the valley returned. In 1871, unfortunately, old Chief Joseph passed away, and his son, also named Joseph, became chief and continued the effort to get the valley returned. The illustration on the left on the PowerPoint slide is old Chief Joseph, and the picture on the right is of young Chief Joseph. Young Chief Joseph's lobby had paid off when in 1873 an executive order was signed by President Grant reestablishing title in Chief Joseph's band with a new independent reservation. Unfortunately, though, it didn't last long because Oregon's governor and congressman objected and got President Grant to rescind the order in 1875. Chief Joseph and his band continued to occupy the valley when in 1877 the government gave them a 30-day notice to relocate to the Wallowa Reservation in Idaho. Chief Joseph's band refused and chose to flee to Canada to join Sitting Bull's tribe, who was already there. They engaged in multiple battles with the army along the way. The PowerPoint slide shows a map of their path from Oregon to the Bears Paw Mountain in Montana, where they were captured 40 miles short of the border. This is when Chief Joseph utters his famous line, "I will fight no more forever," which is also the title of the 1975 movie. Chief Joseph was eventually moved to the Colville Reservation in Washington and was never allowed to move back to the Wallowa Valley. He passed away in 1904 after spending the remaining years of his life lobbying for the return of the valley. 25 years later, in 1929, however, the descendants of Chief Joseph's band filed a legal claim with the U.S. Court of Claims. As the plaintiffs, they claim that Chief Joseph had a recognized title in the Wallowa Valley and that the 1863 treaty was not valid without his assent. Unfortunately, the court didn't agree and held that Chief Joseph did not have any recognized title in the valley and that the 1863 treaty was valid based on the simple majority of signatures of the other chiefs. This was obviously a setback, and no known appeal has been made to date. Fortunately, however, the Court of Claims was set up such that an appeal is made directly to the U.S. Supreme Court. The legal basis for appeal here is that the U.S. Court of Claims erred when it held that Chief Joseph did not have a recognized title to the Wallowa Valley. The best case made to date for an appeal was suggested by John Flanagan in a law review article where he argues that the Court of Claims failed to recognize the cultural considerations and the greater context of the Native American way of life in determining status of title to the Wallowa Valley. His argument is that based on an autonomous structure of ownership of land within the Nez Perce, the court should have held that Chief Joseph's band did have a recognized title in the valley. There is proof through testimony and reports that the government recognized this autonomous structure with the Nez Perce and made oral promises with the 1855 treaty based on this recognition, which was not reflected in the written treaty. It was known that the Nez Perce did not speak or write English, and they relied on the promises interpreted to them, and the court should consider these circumstances in determining the true rights established in the 1855 treaty. The cultural consideration argument presents the true intent of the parties, proving that the government, including both Congress and the executive branch, recognized title in Chief Joseph. There's direct testimony from 3 government agents from commissions set up in 1873 and 1876 representing Congress and the executive branch that they recognized title in Chief Joseph and that the 1863 treaty should not be binding on Chief Joseph. Despite it not being specified in writing in the 1855 treaty, there's plenty of proof that there was a widely recognized title in Chief Joseph with the cultural considerations. The 1873 executive order also offers proof of a recognized title in Chief Joseph. The Court of Claims held otherwise, but testimony from the official report of that 1873 commission proves they erred on this decision as well. The 1873 commission mentioned earlier only met with Chief Joseph and his brother Olcott regarding disposition of the Wallowa Valley, and they reached a compromise to give Chief Joseph half the valley and a new reservation, which was then created by the executive order. This offers incontrovertible evidence that the executive order was exclusively for Chief Joseph's band, refuting the court's claim that it wasn't establishing that the president did recognize title in Chief Joseph. There is one more legal argument in support of a recognized title. It is based on a failure of the court to consider the basic contract principles when the government made an offer to Chief Joseph directly with the 1863 treaty, thereby acknowledging that as the offeree, Chief Joseph was the only one who could furnish the title. The Restatement Second of Contracts, an important treatise in understanding contract law, states that with an offer and acceptance, it matters who the offeree is. Section 52 specifically states that an offer can be accepted only by a person whom it invites to furnish the consideration. This is precisely why the government deliberately made the offer to Chief Joseph separate from all the other chiefs and all the other parties, because they recognized his title. It was actually young Chief Joseph who indirectly raised this argument that the 1863 treaty violates the basic contract principles, that only the true owner can provide the consideration when it comes to an offer and acceptance. He told a parable to the 1876 commission that explained this very issue. The full parable is shared in the article on chiefjosephappeal.org, but it is an excellent illustration of the maxim in contract law that when we make an offer to someone, it's because we recognize they are the owner and alone have the right to convey title. It's a good argument. Young Chief Joseph understood that. And that's why he made the argument to the 1873 commission. Bottom line is that all these arguments have merit. And if any one of them are successful, it establishes that Chief Joseph had a recognized title, and therefore the 1863 treaty would not be valid, and the Wallowa Valley would need to be returned. Flanagan's cultural considerations argument alone might be enough to win the appeal. We have testimony and reports that agents representing Congress and the executive branch recognized title in Chief Joseph and advocated for return of the valley. There is solid evidence in the official report of the 1873 commission that the executive order issued by President Grant was exclusively for Chief Joseph's band. We also have the argument that the 1863 treaty negotiations provide proof of a recognized title by the government based on basic contract principles. It's simply hard to reconcile the Court of Claims conclusions with all the ways title was recognized in Chief Joseph from Congress to the president, down to the other Nez Perce bands. It's time to test some of these theories and take a swing at an appeal. My hope with this presentation is to keep the hope alive for an appeal and build support to help the Valley get returned to Chief Joseph's people. You can visit chiefjosephappeal.org to read my full article that includes Chief Joseph's parable, plus the two treaties, the decision by the Court of Claims, Flanagan's article, and more about the potential for an appeal. So thank you for your interest in Chief Joseph and for this cause.